Honor.
It is based on the list that you provided, and
That didn't have a time. That didn't have a time or of
I'm not going to play
order.
this game with you, sir.
It's not no game. That's what you don't seem to understand.
I believe that fully.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody. That's what nobody. You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor. Nothing about this is a joke. That's what y'all don't understand.
But there's
and it's unfair. It's unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So I think, Your Honor, with all due respect, I think you should show some respect.
We're going to take a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness.
Okay, and that has been what's going on in this trial. Now, if you guys are not familiar with Darrell Brooks, that was an excerpt of his trial that has been going on for the last 17 days. It has been nothing but arguments with the prosecution, arguments with the judge, basically putting the judge in her place, telling her that she don't know what she's talking about. She can't just tell him what she want to tell him. She has not made subject matter jurisdiction. She has not called things on the grounds of what it is and what it is. And we're going to get right down onto the nitty and gritty of it. So as you see there, that is the trial of Darrell E. Brooks. Now, some of you guys have been watching this trial and some of you guys did not watch. So I'm going to bring everybody up to speed all together. And then we're going to get back to those crazy excerpts of these court battles and exchanges. So let me give you guys a quick breakdown. So on November 21st of last year, there was a parade in Waukesha, Wisconsin. Now, when you look at the spelling, it looked like it said Waukesha, but I guess it's Waukesha. And he was an angry, disgruntled Dusty who was mad at his baby mama because he had did something to her prior and he wanted money up out of her, to which she didn't have to give. And in an angry, disgruntled manner, he decided to go to the parade and topple over and run over people. Now, during this parade, there was children in the band. There was old grannies, dancing grannies. There was all kinds of different people putting on this Christmas parade. Now, in the midst of him getting into it with his baby mama, he leaves from dealing with her and goes full throttle down the parade and killing 6 people and injuring 62. Okay, to which he received 76 counts of charges, with 6 counts of it being first-degree intentional homicide. Okay, so let me give you guys a quick recap of the goings-ons with the parade, and then we are going to get more in depth into this story and tell you how we're going to get back there. All right, so here we go. All right, so as you see right here, this red vehicle that is flying down the street is a vehicle that was occupied by Darrell Brooks, the guy who was just screaming at the judge. So as you see, there's this kid with the pink pants, and he barely misses her, trailing down the street to ongoing parade participants. Okay, so as you see there, he goes full throttle and he was going about 40 miles per hour, but 40 miles per hour was enough speed to do a lot of damage and injure a lot of people.
9 p.m. The red SUV drove into our Christmas parade that we were holding downtown. More than 20 individuals were injured as a result of this incident. The Waukesha Police Department has recovered a suspect vehicle. It's an ongoing investigation. Victims were actually transported from the scene via ambulance. Officers actually transported some of the injured personnel and took them to the hospitals, and some victims were actually transported by family members and friends to the hospitals. Very tragic incident, very chaotic. There is no other threats involved. The scene is now safe.
All right. So as you see there, it was a very chaotic and traumatizing experience for those who were in attendance of this parade. There was people who were injured, there was people who lost their lives, and there was a lot of tragedy and devastation to trail behind it. Well, after this incident went down and he plowed into these people, he tried to first act as though it wasn't him. He tried to act like he didn't have anything to do with it. He tried to act like he didn't know what was going on. And he tried to act like, it is a case of mistaken identity, even though the car that he was driving was a car that he had flossed in a music video where he was trying to pursue a rap career. And even though this was the same car that belongs to his mama, as far as I know. Now, let me show you some of his interrogation video, and then we're going to move on down the story.
You left Stephanie's.
It was still daytime.
It was still daytime?
Yes.
Okay. Were there still a lot of people out?
It was still people out.
Okay.
It was still people out. Not a lot in that area. By the park, it was a lot of people out.
Okay.
Like I said, it looked like something was, I don't know what the hell. But it was a lot of people out. And it was, like I said, it was people, it was older couples walking down the street. It was younger people walking down the street. People
was like an event or something was going on?
I don't know, but it kind of seemed like it was a lot, like it was something going on to where it was vibrant. Because there was a lot of people everywhere.
Walking up and down the street.
Everywhere. It's people. That's what I'm saying. Like, if I got into a fight with her right there, it would be impossible for somebody to not be like, hey, this guy's fighting this chick or whatever the case may be. Like, how could somebody not see something?
How long was it between leaving Stephanie's and those cops yelling at you at the door of that guy's house?
Was it dark when they yelled at you?
Yeah, by the time they came, it was dark.
Okay.
But we had been sitting out there. We had been sitting out there for a minute, me and the guy. We was sitting right there on the porch. We was just sitting there.
Define how long, estimate.
Okay, so as you can see there, he's basically trying to play dumb. He's trying to act like, hey, I don't know what you're talking about. If I put the paws on my baby mama, somebody would have seen it. Well, somebody did see it, sir, and the surveillance cameras caught you in the act. So that was the first instance, but let me read to you the facts of what happened. So it says, during the immediate aftermath of the ramming, 5 people were confirmed killed and 48 others were injured. The 5 dead were identified as 4 women and 1 man. 4 of the dead were members of the Milwaukee Dancing Grannies, a dance group composed solely of grandmothers. Hospitals admitted 28 people and 9 were in critical condition. 17 children were among the wounded, 3 of whom remained hospitalized at the Children's Wisconsin's until early December. By November 23rd, the number of people reportedly injured had increased to 62, and the number of fatalities had increased to 6 after an 8-year-old child died at a hospital. The ages of the dead ranged from 8 to 81 years old. Now, on the same day as the Waukesha attack, police recovered the damaged Ford Escape, and they arrested 39-year-old Darrell Edward Brooks Jr., and it says that he had a very extensive criminal record. Okay, So in addition to this extensive criminal record, he had an ongoing tumultuous relationship with his ex-girlfriend. So it says Brooks had been arrested 3 weeks prior to the Waukesha attack for hitting his ex-girlfriend with the same vehicle during a domestic dispute. The charges against him for the case include a second-degree recklessly endangering safety with domestic abuse assessments, a felony, as well as disorderly conduct with domestic abuse assessments, misdemeanor battery with domestic abuse assessments, and obstructing an officer. Brooks posted a $1,000 bail on November 19th, 2 days before the Waukesha attack, and he was released. At the time of the attack, Brooks also had an outstanding warrant for a statutory crime in Nevada, which was issued in 2016. Brooks was arrested the night of the attack soon after telling a Waukesha resident that he was a homeless man and that he was waiting for an Uber. The man was unaware of the events that had occurred and permitted Brooks briefly inside his home, giving him a sandwich and slippers, but asked him to leave when the police arrived. Brooks had initially been charged with 5 counts of first-degree intentional homicide following the death of 6 victims. Brooks' bond was set to $5 million, and he was remained in custody. It says, follow an initial court appearance, the Waukesha County District Attorney said more charges were likely to come, and they charged Brooks with a 6th count of first-degree intentional homicide on November 29th. It is believed that he basically acted alone, and he was basically a disgruntled Dusty who got mad at his baby mama and took it out on the fellow people of Waukesha, Wisconsin. Now, there was a lot of people who felt like, in addition to the 61 counts of charges and the first-degree counts of unaliving people, people felt like there should also be hate crimes added in addition. So once there was a lot of research done, there was people who dug up the fact that he had previously had this wannabe rap career. Okay, and in his rap career, he had also advocated, in songs and on social media, that he wanted to advocate for violence against white people and Jews. He was reported to have posted the phrase, Hitler knew who the real Jews were, and Hitler was right on Facebook during his, amateur rap career, and he rapped about being a terrorist and a killer in the city. So there was a lot of people who took that into account and wanted him to have additional charges for this to be escalated to a hate crime. However, it did not escalate to that magnitude. It just stayed at the 6 counts of intentional homicide and the 61 counts of the other charges of injuring the people. Okay. Now, in the trial, they were able to recover the vehicle. They were able to allow the jurors to look at the vehicle. They inspected the vehicle because after he tried to act like it wasn't him, then he tried to act like, oh, well, y'all caught me red-handed. It was me, however, or he still tried to allude that it wasn't him, but he tried to also make it seem like there was faulty brake systems in the brakes. Okay. So they were able to examine the vehicle and determine that there was nothing wrong with the brakes. The brakes were perfectly fine and operational, and he did have the capacity to stop the vehicle. There was no type of indication that he ever tried to stop, and that is the next exhibit that I will show you guys as we move right along.
6 people, injuring dozens of others. And for the first time, jurors got a close-up look at this vehicle.
Bruce Harrison shares more on what unfolded today inside the courtroom.
Other than the vehicle, anything you see there is not evidence in the case.
Quick instructions from the judge before jurors trip to the garage. Here's what they saw. The state calls it the deadly weapon, a major exhibit on trial day 13 as the state prepares to rest its case.
Any other observations made with regard to in that area?
The state also called a patrolman who inspected the SUV.
All the brakes were in good working condition and had adequate thickness left on the brake pads for stopping of the vehicle. All 4 brakes were in good working shape and they were able to be locked at the time of inspection.
And in earlier testimony, an officer says he found a critical piece of evidence.
I located in that platform area, I located the gray hooded sweatshirt that had a multicolored design. It's the same sweatshirt that we believe Mr. Brooks was wearing during that parade incident.
So it would be fair to say you didn't know who the items belonged to at that point?
Fair enough, yeah.
Brooks continued lengthy cross-examinations and commentary the state called out.
When the court overruled one of Mr. Brooks' objections, his response was, stop trying to be slick.
Yeah, I did say that.
So, just for the record, I thought that that was very disrespectful.
Thank you, I would agree.
The state has suggested several dates over the course of this trial that when it would wrap up and rest its case, all pushed back for various delays. But tonight, they're on their second to last witness. They plan to push through one more push to get to that last witness and rest by this evening. From tomorrow morning, we then expect Darrell Brooks to begin presenting his defense and calling his witnesses to court. Steve, Carol?
Bruce, thank you very much. And don't forget, you can watch live gavel-to-gavel coverage of the trial of Darrell Brooks.
Okay, so as you see there, he was made aware that there was nothing wrong with the vehicle. He could have stopped, and he also had smoke for the people who had stuff to the prosecution. Well, in the midst of the trial, they were to call witnesses, and one of the witnesses that was to be called was his baby mama. Now, in the course of this trial, there was additional charges made to him because it was revealed that he had made several phone calls via the jail to try to threaten her against testifying. And that also worked against him in this whole proceeding. But hold on, let me fix the camera because I'm having difficulties. Hold on one second. This new camera that I have is sometimes overheats and it's annoying. So hopefully we could get through it. So anyways, let's go to the next. So he had basically, once he was not able to get the witness testimony thrown out of his baby mama, she was basically called in to testify because this all was a catalyst of them going back and forth. So he basically got into it with her, and it was this domino effect of him not being able to control his damn emotions. Okay? And so he tried to discredit her and make her out to be like she was this bad mom and that she was incredible and things like that. And the prosecution basically called him out because they're like, sir, when you got with her, she was a minor. And if she was a bad mom, it's all because of you. You had a part to play in her being a bad mom, etc., 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 because you impregnated her when she was still a child. So let me play that.
To question you about that, or question this witness, and to look at the veracity of what your claims are here. So when I may take an early lunch, If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How
Okay.
many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we can
assumes-
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic
Because
where you try to
it's not a
go
tactic,
off of
it's
what
facts.
we're talking
It's
about
facts.
to some other reason.
It's facts.
to
Because
some
I
other
find it
thing.
hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from him?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the
finish.
end of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she
disrespectful,
told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the
All
record.
right, under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess, 1 hour.
Get your facts straight.
All right. So he basically was hotter than fish grease, and she was also called to the witness stand. So she came and gave her testimony, and we are going to listen to some of it right now. Let me pull it up. She is 32 now, but I guess at the time that she met him, she was 15 years old.
Morning, Ms. Patterson. If you would please make your way to the witness stand, which is upper riser and to my right. When you get there, please raise your right hand. My clerk, Teresa, who's standing over here, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, ma'am.
Thank you. Have a seat. First thing I will have you do is to state your first and last names for the record and then spell each.
Okay. Erica Patterson, ErikaPatterson.
All right, thank you. Go ahead, your witness.
Thank you. Good morning, Ms. Patterson. How are you doing today?
I'm fine, thank you. Sorry.
All right. Can you tell us, do you know a man by the name of Darrell Brooks?
Yes, sir.
Your Honor, I'd ask that the court have Mr. Brooks temporarily remove his mask.
Mr. Brooks, you're advised to remove your mask, please. Thank you.
Ms. Patterson, do you see Darrell Brooks in the courtroom today?
Yes, I do.
Can you tell us where he's sitting and what he's wearing?
On the left side, and he's wearing an orange shirt and a mask.
I'd ask the record reflect that the witness has identified the defendant.
The record will reflect that this witness has identified the defendant.
Can you tell us how long you've known Darrell Brooks?
Since I was 15.
How old are you now?
32 today.
Oh, happy birthday.
Thank you.
What's the nature of your relationship with Mr. Brooks?
We have a 15-year-old daughter together.
Okay. In what state did you meet Mr. Brooks?
Reno, Nevada.
And when did you come to Wisconsin?
Last year, 2021, June 13th.
Why did you come to Wisconsin?
We were coming out here. I was going to be out here for 2 weeks and go back, but I never went back.
Who did you come to Wisconsin with?
Darrell Brooks.
Where did you live when you got to Wisconsin?
Atlanta, Georgia. Oh, we lived with his mother, sorry.
Mr. Brooks' mother?
Mm-hmm.
In what city was that?
Hold on, was that a yes?
Yes, I'm sorry.
That's okay. That's what my job is, to make sure the record is
Yes,
clear.
ma'am. Milwaukee, Wisconsin.
Okay. At some point, did you stop living in Milwaukee and start living in Waukesha?
Yes, I did.
Do you remember approximately when that timeline was?
November 2nd, 2021.
Okay. Where were you staying in Waukesha?
The women's shelter in Waukesha.
That's downtown?
Yes.
Okay. Do you know a person by the name of Corey Runkle?
Yes.
Where did you meet Corey Runkle?
The women's shelter.
Were you roommates?
Yes.
Okay. I want to direct your attention to the date of November 21st, 2021.
Yes.
Did you know anything about a parade happening in Waukesha that day when you woke up that morning?
I didn't know about the parade.
Okay, what about that afternoon? Did it become apparent to you that something
Yes.
was going on?
Yes.
Did you come into contact with Darrell Brooks on the afternoon of November 21st, 2021?
Yes.
Where did you first come into contact with Mr. Brooks?
At Frame Park.
And how did that come about? What were you doing and why did he get there?
We were messaging and calling each other all day. We were arguing back and forth. He came out there. Well, I told him I was with Miss Corey, and he came out there. I told him where I was. Got in his car. We drove around. And then I forgot the street. We went up that street. It's a hill. It's kind of by the Walgreens. We went up that hill. We drove around. Me and him got into an altercation. He hit me in my eye. I jumped out of the car, walked, and found my way back by Frame Park. And then he followed me there. And then I went back in his car. I got out, and I had called Corey. Well, I called Corey before that. And she came to meet me. I told her that me and him got into an altercation. So she met up with me, and by the time she got there, she pulled me out the way because his car turned around. He swerved. She pulled me out of the way. He got up his car, and they got into an altercation. He pushed her in her face, and I don't remember if she hit him back or anything. After that, we walked away and walked back to the women's shelter.
Okay. Let's go back and go through some of the details of that, all right?
Yes.
You said that you told Mr. Brooks that you were hanging out with Miss Corey.
Yes.
Were you hanging out with Corey Runkle earlier that day?
Yes, her and her friend Nick.
Okay.
Yes.
Do you remember where you were with those two?
It was at the Frame Park because we had split up when I met up with Darrell.
Okay. Do you remember what you were doing in Frame Park with Corey?
We were just hanging out.
Okay. Any alcohol involved?
Yeah, a little bit.
Do you
They
remember?
had like a Mike's Hard, the little Mike's Hard beer.
Okay.
Yeah.
Would you say that you were intoxicated after consuming one Mike's Hard beer?
No, I was not.
Okay. And at what point did you split up with Corey?
When Darrell was on his way, Corey and Nick had left, so I sat there and waited for him. We were still arguing on the phone, but I waited for him.
And you were in Frame Park?
Yes.
Okay. How did Darrell arrive? That is, he didn't walk to Waukesha.
He drove in his mother's car. It was the red, was it a Ford, I believe? I'm not sure what kind of car, but it was the red.
Had you seen him driving that car on previous occasions?
Yes.
Had you ever been in that vehicle before?
Yes.
When you were staying with Mr. Brooks' mother, were you staying in the house?
No.
Where were you staying?
We were outside. Sometimes we'd sleep in that car because his mom, he was not allowed to, be in the house. So, yes.
And you slept in that car with Mr. Brooks?
Yes.
That was before November of 2021?
Yes.
Okay. Describe for us what happened when Mr. Brooks first arrived in Frame Park, when you first saw him that day.
We were still arguing, pretty much. He was already in a bad mood when he met up with me anyways.
This was an argument that face-to-face, using words, not messaging,
Yes.
right?
Yes.
Okay. Did you get in the vehicle?
Yes.
Okay, and what happened next?
We drove around and were arguing, and that's when we got into the altercation in the car, and that's when I jumped out. We were up the hill.
Do you remember exactly the route that the two of you took while you were driving around?
Objection, relevancy.
Overruled. She may answer.
Yes, I do. I'm not sure the exact street names. Like I said, I'm not from Waukesha, but I do know the route.
After, the next day you met with Detective Steve Guthier, is that right?
Yes, it was the same day.
Okay. And you got in the squad car with Detective Guth.
Oh, that was the next day, yes. So.
All right, so they ended up showing video evidence of him meeting up with her. And him pulling up and everything like that.
We've paused at 1 minute and 37 seconds. Miss Patterson, who did we see in the video there walking?
Me.
Okay. And we saw a red SUV, right?
Yes.
Who was driving that SUV?
Darrell Brooks.
Was there anybody else in the vehicle at that point, to your knowledge?
Nope.
Okay. Let's resume playing.
Somebody said it seems
Pause
like
there.
his mom knew he wasn't right in life, and she did.
At 4 minutes and 17 seconds. The two people who just entered the screen from the right, do you know who they are?
Corey and Nick.
Do you know which is which?
Corey's on the left, Nick's on the right.
Let's resume playing.
His mom had basically submitted a note saying that he had a long history of mental health problems, et cetera, et cetera. So she of course, she knew.
Mr. Brooks.
Okay.
And then she was running after me.
And we can stop it there at 6 minutes and 54 seconds. What did we see in that clip, Ms. Patterson?
I walked away from Corey and Nick because I was mad because me and her started arguing after that because she was mad that I even met up with Mr. Brooks.
Okay.
And then she was running after me.
Do you know the direction that you were walking there?
Straight. And then...
That's fair. Walk's just
Sorry.
confusing.
So how would you know exactly if the conversation was argumentative? Why would you agree to meet up with the alleged defendant?
I do not know.
Okay, so this is where he cross-examines her. I'm not gonna look at the whole hour testimony. Or the hour cross-examination. I'm gonna just skim through a little bit of it. So
Via the telephone, would that be fair to say?
Yes.
Texts, phone calls?
Yes.
Around what time of the day was that?
I don't remember.
Objection closed.
All right, thank you. Mr. Brooks, do you have any questions for this witness?
Yes, I do. First of all, good morning.
Good morning.
And happy birthday.
Thank you.
You stated that you were hanging out with your friend Miss Corey on the day of this incident, correct?
Yes.
Would it be fair to say that you were hanging out drinking?
Yes.
Would it also be fair to say that you occasionally drink too much?
Objection, colleagues.
Sustained.
Would it be fair to say that, well, let me back up. What were you drinking?
A Mike's Hard beverage.
Were you aware that it was said that you were actually drinking vodka?
No.
Hold on. When there's an objection, I need to rule on it first, okay?
Yes, ma'am.
Sustained that mischaracterizes the previous testimony. Next question.
So it would be fair to say that you were drinking.
Yes.
Would it be fair to say that you were a little intoxicated?
I was not.
How much did you drink that day?
1 of the Mike's Hard alcohol beverage.
And around what time of the day was that?
I don't remember.
Was it shortly before meeting up with the alleged defendant, or was it sometime before?
It was before.
It's so crazy to hear him talk about the alleged defendant. Nigga, you are the damn defendant. Was it fair to say whatever when you met up with me and I put the pause on you? Because I'm the alleged defendant? Child.
Four.
Did you have anything to drink after?
No, I did not.
You stated that you were engaging in a conversation with the alleged defendant via the telephone. Would that be fair to say?
Yes.
Texts, phone calls?
Yes.
Were those texts and phone calls of what nature were they of?
Me and Mr. Brooks were arguing throughout the day.
In the texts and phone calls?
Yes, we were.
If the conversation was argumentative, why would you agree to meet up with the alleged defendant?
I do not know.
Do you recall how the meetup was supposed to be set up?
I don't recall.
Did you at any time ask the alleged defendant to meet up with you?
Well, I told Mr. Brooks where I was.
Did you at any time ask to meet up with the alleged defendant?
No, I did not.
So it would be fair to say that the alleged defendant just came where you were?
Yes, I told you where we were. And obviously, we were going to hang out. I never told Mr. Brooks to hang out with me. I told him where we were.
So why would, if there was an argumentative conversation prior to you meeting up with the alleged defendant, why would you tell the alleged defendant where you were?
Objection, asked and answered.
Sustained.
You just stated that you really don't know the city of Waukesha. Would that be fair to say?
Yes.
So how would you know exactly where you were?
Because I was with Corey and she's familiar with this area.
Would it be fair to say that Corey overheard these conversations between you and the alleged defendant?
Yes, she was my roommate. She heard every conversation almost.
You say every conversation, what would that refer to?
When she was in the room with me, when I was always talking to Mr. Brooks on the phone, she would hear the conversations. She heard me and Mr. Brooks, me, Erica Patterson, and Mr. Brooks arguing the day of the parade earlier before we left.
So it would be fair to say that you were engaged in conversation with the alleged defendant before you even left the women's shelter?
Yes.
And those argumentative conversations continue into your hanging out?
Yes.
Would it be fair to say that that's what led you to drink?
No.
Would it be fair to say you were drinking because that's what you wanted to do?
Yes.
Is it true that one of the rules and requirements of being at the women's shelter is no drugs and no alcohol? Would that be fair to say?
Yes, but when I was drinking, it was at Frame Park. I was not at the women's shelter.
Would it be fair to say that you knew you had to come back into the women's shelter at some point that day, that they have a curfew? The women's shelter, no drugs, no alcohol.
Yes.
Sustained. Next question, Mr. Brooks.
Is there any type of drug and alcohol testing at the women's shelter?
I don't know. No.
No, or you don't know?
I don't know.
Would it be fair to say that if it was found that you were engaging in drugs and alcohol, that you might have lost your place at the women's shelter?
I'll object. I don't see how this is relevant.
Sustained. Next question.
So around what time were you hanging out with Miss Corey, you said?
I don't remember.
Do you remember where you were at?
Frame Park.
Do you remember where in Frame Park?
No.
And approximately at what time did you meet up with the alleged defendant?
I don't remember.
How long were you with the alleged defendant? Do you remember that?
Approximately 35 minutes.
Do you recall what, well, you said that during this time you were with the alleged defendant that there was a arguing going on. Would that be fair to say?
Yes.
Do you remember what that argument?
I give directions when I barely knew Waukesha myself. At me, arguing with me.
So you said absolutely nothing at all?
I was crying the whole time.
Did you say anything?
No.
A few more questions.
Go ahead.
You said that during this, well, once you had got out of the vehicle, as you say, you stated that your friend Miss Corey pulled you away from the vehicle because it swerved?
Yes, it was in the video.
You do know that we just saw the video. Would that be fair to say?
Yes, but there's two angles of the video.
Well, we only saw one, so I'm referring to the video that we saw.
Corey pulled me out the way when Mr. Brooks made a U-turn, and you almost swerved into Miss Patterson, which is me.
Would it be fair to say that the video does not show that?
There's different angles, but the video does not show that, the video we watched.
So the video that we just watched, that the jury just saw, there is no swerving of the vehicle and you being pulled back. Would that be fair to say?
From that far angle, you can kind of see it. Yes.
Would that be fair to say?
You answered the question, Mr. Brooks. Next question. Under 906.11 sub 1 sub C, I direct your attention to that next question.
All right. So as you can see, that's basically the cross-examination of his baby mama ex-girlfriend, who was a big portion of this case because that is basically what spiraled all of these events into motion. Now, as the trial continued, he continued to get into screaming matches with the judge. He continued to challenge her authority. He continued to make sure that he declared subject matter jurisdiction had not been adjudicated on the record. He wanted to know the grounds of this, the grounds of that. And he even ended up declaring or requesting a mistrial because there was a Reddit user who basically trolled and posed as one of the jurors. Now, we're going to get into the Reddit post in a second, but let's see some of the back and forths that he had with the judge, okay? Because they had a lot of goings-ons that was goings-ons, and it was crazy.
Are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I merely asked, how did it get there?
Sir, do not interrupt me, or you will forfeit your right to be present in this courtroom.
So you're holding me in contempt? Are you holding me in contempt?
I'm going to make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt?
Do not interrupt me again, or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're going to clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right. No, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit anything.
I'm going to start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody, and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out, and we're continuing. We're going to get through these witnesses.
And I'm not stopping you from doing that.
Through your behavior, you're not going to delay these proceedings today.
I'm not trying to delay the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to do.
I'm bringing the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's
because I'm tired of you always making a record.
At me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately.
You're making a record of incorrect statements. That's what you're doing. You're not making a record of not being.
I'm advising you to be quiet because the jury's coming back out.
You're advising me to be quiet? Is you telling me to be quiet?
I'm advising you to be respectful when the jury comes out.
Are you telling me to be quiet, or are you asking me?
I'm asking you and advising you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
we're all adults in here. I've never told you to do it.
Child, they about to tell you what to do for the rest of your life. Okay, they about to tell you when to eat, when to sleep, when to shower, when to cough, when to spread them cheeks, when to get the soap, when to give the soap. Child, you about to be told what to do for the rest of your everlasting life behind bars.
Anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Okay.
Thank you, sir. I don't have any other questions.
All right, sir. Mr. Brooks, do you have any questions for this witness?
Yes, I do. And I object to being called that name for the record. Do you recall giving a statement to Officer Probst?
I don't know his name, but I've talked to an officer.
And you did talk to an officer that night?
I talked to an officer on the phone. I did not talk to an officer that night. I mean, on the phone I did, but not in person.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
Who's you?
Or mixed.
Who's you?
Hold on, you have to let him answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time?
I was giving a general description.
So it would be fair to say that you weren't sure?
I was positive it was you.
Who is you?
You. I'm looking at you.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion? Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You were the guy.
And how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
So is it possible you saw something on the news?
No, I had no idea who you were.
Interesting. Do you recall giving a description of approximately 5'9" and 160 pounds?
Yeah, something like that.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
You have your shoes on or off right now?
Would it be fair to say that I'm not 5'9", 160 pounds?
If you take your shoes off and step out of them, they could have a better...
I'm not going to have them do that, but if you're able to answer the question, do you agree?
I'd have to be standing next to him. That's what I made my judgment from. We were about 2 feet from each other.
Does it look like I'm 5'9"?
I don't know. We were a lot closer.
Does it look like I'm 160 pounds?
Objection.
Grounds.
It's irrelevant as to his appearance today, just like his hair isn't in dreadlocks today. Sustained.
Objection.
The trial was a mess. It was a complete shit show. Okay? He was arguing with the judge, telling her her life ain't on the line. His is. He had a lot going on, child. Time after time after time.
None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with
So
the
just
state that
know that.
she could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to
said,
have her here at 9 a.m.
We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a judge?
Brooks, I need to make a record of some
I need to make a record, too.
You don't
When am I going to get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
All you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to make.
I'm gonna give you what you know is coming.
I need him to go to the other courtroom because I do need to put some things on the record. The record should reflect
the contract between you and I?
Mr. Brooks
if it's
is
criminal,
yelling at me.
What is the crime?
He is.
Who makes the claim? And what is the...
I will make the record when we get back. I will step off, but Mr. Brooks, you're being taken to the next courtroom.
Mr. Brooks, don't try to address me like that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
So I'm not arguing with you, sir.
I just want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I
because
don't consent to that, Your Honor, because
you don't have to consent.
I
but here we go.
Let me to being cut off right when I'm trying.
All right,
to
I'm just
going to
talk over him for a minute. I do not have any other information regarding the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me if you so choose.
That is incorrect, because just yesterday you were trying to obtain the witness list that was in my cell. You had noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognized her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
Decision making and put my findings on the record, but his behavior started very early on. I gave him ample opportunity to abide by the rules of decorum. I gave him ample warning before he was removed. This court, frankly, has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings. With that, I will turn back to Attorney Opper. I am going to unmute Mr. Brooks, but also advise him that if he interrupts Attorney Opper or others as they are providing testimony here today, I understand he can object. However, my expectation for that objection process would be that he expect him on a piece of statutes, including the rules of.
You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold
about.
on a second. Mr. Brooks, the basis for your objection at this time?
That is irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize.
Jail cell.
Yes, ma'am, to the best of my knowledge.
Okay.
Is
he still
I object
able?
to that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity. Your objection is overruled.
Will she be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I am turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object just like she objected when I was asking
Right,
questions.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms. Molenhop, while on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials, is that correct?
Correct, ma'am.
And you've indicated
I
previously.
object to that respectfully, Your Honor.
So, an objection goes to whether there's lots of rules of evidence that apply, but if you're objecting to her answer, that's a different thing. You can argue the meaning of that language.
Question,
Okay,
not
the
the
objection,
answer.
but then you have to say objection before she answers. You
She
objected
didn't
after
answer.
she
She
answered.
didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail, correct?
I respectfully object to that.
Overruled, she may answer.
Correct. He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer.
Correct, ma'am. And
So you're gonna
the
overrule everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has the criminal statute.
Child, the judge kept letting him do way too much. So anyways, let me fast forward because he ended up having his closing statements. So when he gave his closing statements, and it was, like I said, basically a shit show throughout the whole thing, he tried to get sympathy, okay? He tried to get sympathy by claiming that, number one, it was a faulty vehicle. They were saying, that's not facts and evidence. Then he was trying to say how this affects his children, how he got a letter from his daughter, and then she said that his daddy's not that type of person. He feels so bad because he's not able to, be the father or whatever, in summary, like that he's supposed to be. He feels so bad that his children have to look on the TV and see these types of things about him. And the prosecution was like, everything that he's saying in this ploy to try to get sympathy, talking about his kids, talking about, everything. And then he's trying to make himself cry. The tears never came. The prosecution was like, not once did he say that he was sorry. Not once did he acknowledge the actual victims who are injured. What about those kids? What about the 8-year-old kid that's dead? What about the people who are no longer living? What are you talking about your child, when it's children who are directly affected by what you did, So that was kind of like a mic drop part of it. So then they went into the deliberation stage where the jurors were about to deliberate. So in the midst of them swinging from their closing statements and into the deliberation stage, there was an anonymous user who basically put out a Reddit post. So basically in the Reddit post, there was a person who claimed to be a juror. And they were saying that they were on his side. They were saying that they wanted justice for Darrell. They were saying how they felt like he was unfairly treated. They felt like, that he should not be, behind bars.
I'm extremely concerned about.
Okay, so when he got news of this Reddit posting, he wanted to say he was disgusted by it. He was concerned by it. He wanted to move for a mistrial on the grounds of this person claiming to be a juror.
About this, if anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here and these case laws and
What's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
relief.
Relief.
Like, what are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this?
All right. So he then basically says, for the people to outline the things that they did, they absolutely would have had to have been a juror. Now, this was live streamed every day on social media, and it could be literally anybody. But he was trying to use that as a way to basically get out of this trial. He wanted it to be a mistrial, and he wanted everything to be thrown out and started over, because he's like, listen, this is concerning. They have this Reddit post, they're advocating for me. They're saying justice for me, and this could be a juror. This absolutely has to get thrown out, blah, 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 blah. If you guys didn't see the Reddit post, because it was put online and then they ended up taking it down, I'm going to read some of the Reddit post for you, but I'm not going to read the whole thing because, child, I'm already at an hour. So it says, Reddit user Justice for Darrell posted anonymously as a juror. It says, I am a member of the jury in this case. Here are my thoughts on the trial and this subreddit. So to start with, I obviously shouldn't be here. I'm not allowed to look stuff up about the trial or really have any connection with the internet. But nobody actually follows sequestering rules anyways. Hence, I am obviously posting anonymously. I accidentally wandered here a few days ago from a Reddit or subreddit drama thread on my main Reddit account. Here's my opinion on the trial. First off, I think it's pretty obvious due to the chain of custody that the defendant is in fact Mr. Brooks, and he did do it. However, I've had throughout this trial doubts about various aspects of this case. Number one, the judge is clearly biased against Mr. Brooks. I got the feeling from when I were in the room, and my eyes have been open to how she acts towards him when the jury was out. Okay? So this person is alleging to be a juror, but their first facts of business, they want to talk about how she acts towards him when the jury is out. But it's like, if the jurors are out and you're saying you're a juror, how do you know how she's acting towards him? But he was able to try to delay a little bit with this Reddit post. The judge initially said, listen, I don't think it's enough grounds for me to delay anything. I'm not going to go for it. We're going to go forward per usual. And the jurors continued to deliberate. Now, they deliberated for like an hour and some change yesterday. And then I think like another hour today. So it was like almost 3 hours of deliberation. And they came back with a verdict. Now, when they came back with a verdict, they found him guilty of all 76 charges. He was guilty of using his vehicle as a weapon. He was guilty of killing, the 6 individuals. And there was a lot of people who felt like he was guilty across the board. And there was even somebody in the courtroom who got satisfaction as to the outcome when his charges was being read. There was a person who, in the midst of him being found guilty, they basically called him a piece of dog poo. Okay. And the judge ended up removing them from the courtroom. So I'm going to play that for you right now.
Did I have an answer? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 27 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 28 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 29 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while...
All right. So as the charges were read out, his head was basically sunken down, and they found him guilty of all charges. Now, like I said, in the midst of him being read the charges, somebody ended up calling him a piece of poo.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information.
All right. So they told him to burn in HE double hockey sticks. Okay.
Well, it's obviously quite satisfying that Mr. Brooks has been found guilty and held accountable for his actions. As many of these victims have said, this is a joyous day for that reason. It's also the point where we hope everyone can move on from. The support that we've gotten as this case wore on day after day was tremendous, and we're very relieved. I guess that's the best word, is relief.
Hillary?
I saw you get a tear in your eye when they were talking about Virginia's ashes. You spoke about what this meant to you and the victims. How do you begin to describe what it was like going up against Brooks as defending him, representing himself? Did that change your strategy? How did you get through all that?
Yeah. I mean, legally it changed our strategy, certainly, because if there's an appeal, he can make a mistake in the courtroom and get a new trial, and we have to pay the price for that, we the state and we the victims. So it's changed our strategy in that we had to make sure, and Judge Darrell did as well, the record was very thorough, very complete, and we didn't miss anything. But as far as handling the actual court proceedings, we felt very, very offended by his behavior, his disrespect of the court, the decorum, the families, his insulting the judge, his challenging the judge. That's not the way our system is designed. That was intentional on his part. We truly believe that. He did everything he can except claim that the dog ate his homework. And
all right. So that pretty much sums it up right there. It was a whole heap and crap of a show.
Stated for the record, can that be?
He was mad that they showed his struggle rap video. Child, it was a lot. Okay. So I just wanted to bring that to you guys because a lot of people watched it and they watched it go down in real time. And there was some people who didn't know about it. There was a lot more clips, a lot more trial. There was like 10-hour long streams of trial and footage and, witness statements and, testimonies and all kind of things like that you can go and look up. How the judge had so much patience, I do not know. But I understand that they wanted to make sure that they didn't mute him too prematurely because he could not, the more that they let him go on and talk and act a fool, the less chances he has at being successful at an appeal. Like if there was like a battle with him in the closing statements where he wanted to say that the jury can nullify something. Okay? And so the judge was like going back and forth with him about, no, you can't say that. And he's like, I am going to say it. And then they're like, no, you can't say it. So then he kept telling her he is going to say it. And she was like, you know what? Well, I'm going to forfeit you from doing your closing arguments. Well, the prosecutor who was just talking right there, she was like, listen, judge, let him say it. And we just going to say objection and move on, And so that was pretty much a tactic because had they not given him the chance to do his closing argument, had they muted him and he was a lot less boisterous, he could have been able to then use that as an excuse and say, listen, I didn't have my right to a closing argument, so that's why I lost. I didn't get a right to, put this on the record, and that's why I lost or whatever. So they had a lot of patience with him, but it was to hang himself so that he could not be successful later on. Okay? But yeah, it was a mess. I just wanted to bring that to you guys. It is crazy, crazy, crazy. I'm glad that the ex-girlfriend or the baby mama don't have to deal with him any longer. They have a child together, and it seems like his children are still in communication with him. But, hopefully she gets her life on track. She was 32, or she is 32 years old, and she looks like she's had a very, 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 very rough life. So hopefully without him in her back pocket, she can get herself together. He is going to have to think about his actions, for the rest of his life. And I doubt that he will ever see the light of day. Now, there has not been sentencing as of yet. So the judge said on Monday that she was going to have another hearing where she was going to basically announce the scheduling going forward. So I'm sure on Monday we'll get updated on when the sentencing phase is going to happen. And when the sentencing phase happens, that's when the victims are also going to be able to make impact statements and say how, this affected them and how this is affecting them to try to impact his sentencing. But being guilty of 6 homicides, being guilty of 70 additional counts on top of that, he's never seen the light of day. So whether they give him 50 years, 100 years, 200 years, 700 years, at the end of the day, it all equals you're going to stay in here until you get deleted. Okay. But yeah, that's all for that. Is there anybody who wanted to call in and talk about it? There was a neighbor that spoke to the news and stated he lived with his mom and was always talking to himself. Yeah, I believed it. I watched the trial. He was definitely disrespectful to the judge and the court system, even badgering witnesses. Yeah, he was even laughing at witnesses and all that. Do y'all want to end the live, or is there anybody who watched the trial who wants to call in and speak about it? If not, we'll just end it there. Yep, he screwed like that hairline. Yes, that hairline is a goner, child. That hairline is throwing up Wisconsin. That hairline is throwing up Wisconsin, child. I watched the trial. Oh, okay, I see that part. Stop effing with these losers. Right. The arrest video is on YouTube. Just search Brooks arrest, and it shows him walking up to stranger's porch and made him a sandwich. Yeah, I talked about that already. I didn't show the video, but I talked about it. Somebody said that man is sick. I am from Milwaukee. This is embarrassing. Thanks for covering this, Neek. I love hearing people's thoughts on these court cases. The hairline was looking right. The hairline was all types of out of control. Child, it was a mess. But yeah, let me open up the StreamYard link for y'all and give y'all the link in the chat. I gotta figure out what's up with these cameras, child. Let me put the link in the chat for y'all. All right, the StreamYard link is in the chat. You guys can let me know your thoughts on the matter, child. But yeah, it's crazy though how much a haircut can change your overall look. Because even though he still looks crazy, it's complete night and day from him with the dreads to what we seen in the courtroom. Because with the dreads, he looks 60 years old. But then in the courtroom, he looked closer to his age and he looked closer to 40. But, you know, the dreads, the hair, all of that stuff, it aged him and he looked crazy. There was other pictures where he looked completely cuckoo for Cocoa Puffs. Looks like he looks a lot better with dreads, even though he's still a cuckoo bird. Somebody said, this is why mothers have to stop coddling their sons, making rap videos and running people over in his mama's car. Yes. You said it's more than a haircut. I mean, yes, I'm sure it was probably narcotics involved as well. He definitely looks like Orlando Brown with his haircut. I watched the trial. There's no way he should have been allowed to rep himself. Clear mental issues. He needed an attorney to advocate for treatment while in prison. Kyle Rittenhouse, also in Wisconsin, free man. Yeah, but the circumstances between Kyle and him are different, but still crazy nonetheless. But yeah, so nobody has clicked yet, so I'm going to exit out and I'll catch you guys on the next one. Remember always to go, you said you like him better with his locks? Girl. But I'll see you guys on the next one. Peace.